Thank you. Thank you for being seated. Here. So, let's give a hearty welcome back to Yale Law School professor, constitutional scholar, and media pundit, Akhil Amar. Akhil has surely put Scranton on the map as one of the must-go-to places in the season of Constitution Day. While most universities, obliged to pay homage to the day, scramble to paste together a constitutional program, the University of Scranton's Schemmel Forum, through Akhil's enormous generosity, has not only an easy time, but an extraordinary opportunity to glory in the story of our Constitution, both written and unwritten, its history and its future. I've asked Maury, one of our own local constitutional gurus, to introduce Akhil, so I'll turn the podium over to him now.
Thank you, Miss. It's a great privilege for me to introduce my dear friend Akhil Amar, and for all of us to learn from America's leading constitutional scholar. Just a few days ago, some of you may have read in the New York Times that Akhil interviewed Justice Clarence Thomas at the National Archives Center. Now, Justice Thomas has not asked a question in the Supreme Court for 6 years. Yet Akhil interviewed him for an hour, and there was remarkable disclosure and revealing information. And it will be shown tonight on C-SPAN 2 at 7 o'clock if you want to catch that interview. And at the same time at the National Archives, they released Akhil's new book, The Unwritten Constitution, which is available here for signing after CSANDR, where that will be taking place. Akhil Amar has been lauded on one hand by Larry Tribe and Alan Dershowitz, and on the other by Ken Starr and Justice Thomas. And he is the Sterling Professor of Law and Public and Political Science at Yale. That's the highest prestige that university bestows on a faculty member. He teaches a course not only at the law school, but at the college, and that course is attended by hundreds and hundreds of students. But he's been introduced so many times in terms of his glorious resume. Let me try something different and reference Akhil to sports luminaries of great achievement, and the magic number 4. Jesse Owens in track at the 1936 Olympics, 4 gold medals. Baseball players who rarely hit 4 home runs in a single game. Tennis stars who, even rarer, win 4 Grand Slams in a single year. And now Akhil Amar surpasses them all, having taught in a single year at Yale Law School, Columbia Law School, Harvard Law School, and now the ultimate at the Schemmel Forum. Professor Akhil Amar.
It's such an honor to be back here in the great city of Scranton at this extraordinary university, to be reunited with my friends, Maury and Sandra Myers. I also, though, before I wanted to start my own remarks, just say one word about how fortunate I am to be part of the Schemmel Forum and how much I learned from our last speaker, who took us around the world. So if you'd please just join me and thanking her once again. That was really, truly extraordinary, and damn it, you raised the bar very high for the rest of us. The proverbial impossible act to follow, but nevertheless, that is my job, to follow it. Trudy took us on a tour of the horizon, really across the globe. I want to take you first back in time. They say the past is a different place, a different country, so to speak. And then I want to take you into the future, which is also in some ways a different place. I think that the whole idea of this forum is to be both grounded and expansive, if I understood Sandra's charge to all of us this morning. So let me begin by reminding you all of the past and indeed a triple anniversary that we mark today. Because I don't really think, deep down I'm an historian, I don't think we can really understand our present or imagine our future without engaging the past. And so let me remind you of what happened this week, 225 years ago, 150 years ago, and 75 years ago. So the spirit of 75 thrice over. 225 years ago, this week, I claim, is the hinge of all of modern history. There's a Catholic school such as this, many people might divide the world into BC and AD. But in secular time, I propose that really the world divides between before September 17th, 1787, and after September 17th, 1787. So really, again, 225 years ago this week. Look, and my first theme is democracy in the world. And it connects to Trudy's theme, and I'll try to connect it up very shortly. On September 16th, 1787, you look around the world, very few people are self-governing outside the United States. There is a tradition of some self-government in Britain. They've got a House of Commons and a widespread jury system. They've also got a hereditary monarch who is very powerful, far more than today's Queen Elizabeth. They've got a House of Lords based on a hereditary power. So, but some self-government in Britain. You got a few sheep and goat herders in Switzerland. No Swiss banks yet, so Mitt Romney's not interested. And the Dutch are in the process of losing their republic. And that's it across the planet. Russia under czars, China under emperors, India in chains, Africa in chains, most of the continent of Europe, no real self-government. The world is dominated by kings, princes, czars, emperors, sultans, Mughal lords, tribal chiefs, thugs. You look backward for millennia, from September 16th backward in time, all of recorded history, very little self-government on the planet. A few tiny city-states that had managed to have self-government for a certain amount of time and then blinked out. Athens, pre-imperial Rome, Florence perhaps, but these regimes did not exist over extended geographic areas. They weren't in the end able to defend themselves against larger military structures from the outside and against their own internal divisions. These regimes like ancient Athens involved democracy on a scale in which people met face to face, worshipped the same god or gods, spoke the same language, had the same climate and culture. Nothing like democracy on a continental scale. Nothing at all. And they had blinked out. So very little democracy for all of recorded history before September 17th, 1787. Very little democracy at that moment on planet Earth. Now, flash forward to today. Democracy over half the planet, and it's uneven in all sorts of places. Arab Spring, you know, the jury is still out, big question marks, but but really half the planet in landmass and population. Trudy talked about China. She mentioned BRIC, Brazil and Russia and China, but not as much discussion of India. But that's 1 billion people. Where my parents were born, and when they are born, there's no self-government there, and that's 1 billion people on the American model, you see. Multicultural, multi-religious, multilingual, diverse, lots of free speech, raucous, American-style free speech, sort of a written constitution. India is American in profound ways, and we didn't talk as much about Europe as a bloc, but Europe, Eastern Europe, as well as Western Europe, we all, in our lifetime, the wall came down. See, this spread of democracy, this was not foreordained even, or it wasn't as obvious even in 1900 or 1940. In our lifetime, we've seen the spread of this. So democracy over half the planet, Eastern Europe as well as Western Europe, all of the continent of Europe, that wasn't true in 1787. So my claim is that the world that you live in, that we live in today, is increasingly, at the deepest level, at the broadest level, an American world, a democratic world, a constitutional world, far more than ever before. And that is because of what happened 225 years ago this week. That's the hinge of modern history, that we, the people, actually were allowed to vote up and down a continent on how we and our posterity were to be governed. That had never happened. Even in places that had democracies, they never had democratic constitution-making processes that actually put things to a special vote. Not in Athens, not in pre-imperial Rome, not in 1776, by the way. That wasn't put to a vote. And there wasn't very much free speech in 1776, since democracy isn't just about one person, one vote, one time. It's about free speech and respect for minorities and consensus. It's about many things. It's a thick idea if it's going to be sustainable. And 1776 was kind of thin, truth be told. So not a popular vote and not really robust free speech in the sense that in July 1776, we're already at war. You know, the war has begun a year before Lexington conquered Bunker Hill, the siege of Boston. Washington and his army is already in the field. And the King of England has sent over 30,000 troops to slit our throats. And this is not a philosophy seminar. You're either with us or you're against us. You know? And if you are opposed to independence, here are your choices. 1, leave. 2, shut up. That's it. Okay? Now, 1787, this year that changes everything in human history. Not only is the thing going to be put to a vote, and it could get voted down, and it does get voted down in various places. Rhode Island says no, and North Carolina says no. It's not a fixed, rigged thing. But you also, raucous free speech for a year up and down a continent. You can be for the thing or against it. You can speak out against George Washington. Framers of the Constitution are burned in effigy, but no one is actually burned. No one dies in that whole year-long process, basically. Raucous free speech, but it's not like the French Revolution. It's not like the American Revolution. It's this amazingly peaceful, democratic, free speech revolution that changes the world. This is the Big Bang. We are still feeling the after effects of that year. And people who oppose the Constitution, they go on to be, we call them the Anti-Federalists, President of the United States, James Monroe, Vice President of the United States, Elbridge Gerry, George Clinton, Justice on the Supreme Court, Samuel Chase. No one who opposes the Declaration of Independence goes on to political authority in independent America. They're voted off the island. They're ostracized, in effect. So no one who opposes independence fiercely, who doesn't change their mind quickly during the American Revolution, goes on to anything. People who oppose the Constitution fiercely are heard from again. They actually help give us the Bill of Rights. They lose today They oppose the Constitution, but they win tomorrow. They actually help give us the Bill of Rights. And this is a very robust democratic tradition. You know, a robust democracy, the majority prevails, but the minority actually accepts the legitimacy of the process, and maybe it wins the next time around. This is pretty striking. Who knows whether that will happen in Egypt or Iraq? The jury is still out in these places, Trudy was suggesting to you. But 225 years ago, how do we get the Bill of Rights? We get the Bill of Rights from this epic conversation, bottom up, of the people themselves talking about how Constitution 1.0 is flawed. And in effect, it's crowdsourced, since Trudy mentioned the internet and China. The Constitution is crowdsourced. We call that the ratification process, and through that we get the Bill of Rights. When anti-federalists say, you know, you forgot something, and the federalists say, okay, maybe we did, but we have to get rid of this Articles of Confederation because it's just incompetent. But once we get the Constitution in place, we can fix it. That's actually one of the features of it, is it's amendable. So, and I'm going to talk more about amendment, of course. That's my ultimate target today. But through that year-long process of conversation, we get a Bill of Rights, where Federalists and Anti-Federalists converge after having divided on the Constitution. As soon as the new Constitution goes into operation, they get together, and 5 of the first 10 amendments have the words "the people" in them. It's the phrase that's most common in the Bill of Rights, and that's because it's coming up from the people, and that's why it's in the First Amendment, and the Second, and the Fourth, and the Ninth, and the 10th. And even before, I'll come back to this, we promise textually free speech, the freedom of speech, as if it already exists. Congress shall make no law abridging the freedom of speech, as if it's a pre-existing right. Even before it's textualized, we did it. It was part of the very process, we the people, we do ordain and establish this constitutional process that gives us the Constitution. It's baked into the constitutional cake even before the First Amendment textualizes, which is important because if all of our rights come from the text, I'll say a little bit more about this, but if they all come from the text, well, then the first Congress was free to abridge free speech because the Bill of Rights doesn't come along until 1791. So could Congress in 1790 abridge free speech or in 1789? No. It's part of the structure of the thing, part of the very process by which the Constitution is adopted. And if it were only the text, then you have rights against Congress, but not against the president to speak freely, or courts, or states for that matter. Okay, so that's what happened 225 years ago. It's the hinge of human history, and we mark its anniversary this week, which is why it's so special that we can be together at this time. Now, 150 years ago, the 75th anniversary of the Constitution, to the day, the 75th anniversary of the Constitution, September 17th, 1862, what happened that day? Antietam, bloodiest day in American history, more casualties, and that's 150 years ago this week, 75 years to the day after the signing of the Constitution, which remember, when it was signed, it was just a proposal. It's the year that followed that changes everything, when you know, the people get a chance to have their say. The street, to borrow from Trudy, is heard from. And it's a more peaceful, and it's a raucous street, but really a stunning example of the street at its best. What the framers called the people out of doors, and then 75 years later, not so peaceful. The bloodiest day of American history. And what comes out of that? 150 years ago today, September 22nd, the preliminary Emancipation Proclamation. Because as democratic as this project was, and it's audacious and it gives you the modern world, it was also pro-slavery. One problem with democracy is democracy doesn't always, not only is the problem of the minority, if democracy simply means majority rule, which it doesn't. You see, it's much richer than that. It means free speech and fair elections and a whole bunch of things, respect for proper minority rights. But democracies also have a problem. Even if everyone within the demos, within the people, within the system is protected, what about people other peoples? America's Constitution wasn't designed necessarily at the founding for the benefit of the Brits. On the contrary, to protect us against the Brits, or the Spanish, or the French, or the Native Americans, or the slaves. And this is a reminder that even democracies have to think about what is our obligation, our relationship to other peoples. And as great as the founding was, and I hope you've heard that, I think it was pretty darn good, there was slavery. And it was almost the death of us. And it could have been more easily eliminated at the founding, and the founders just wished it away. Because they just thought this problem of our dependence on foreign oil, our dependence on slavery was going to be the death of us. And by the way, you see, our dependence on foreign oil is shoveling billions, hundreds of billions of petrodollars to tyrants and thugs around the world, whether in Russia or in the Middle East. This is not good for ultimate democracy. These people, many of them don't believe in women's rights and other things. So it's a question of our planet. It's a question of our national security and our national interests and our national values too. So they wished the problem away at the founding, and instead of it just, global warming solving itself on its own, it was almost the death of us. And slavocrats became so powerful and arrogant. The 3/5 clause actually says the more slaves you have, the more votes you have in the House of Representatives and the Electoral College. So slavery became stronger and stronger and stronger. It was a cancer. 3/5 clause is like locking in the wrong compound interest rate. I know that would never happen to anyone today, but when that happens, every decade there's a census, and 3/5 gives more and more power to the pro-slavery party, the party of Jackson, the dominant party in America, and it's almost the death of us so much that they take up arms against a duly elected government. And you can't have that. Democracy cannot work if people who lose an election fair and square try to set it at naught, try to undo it by force of arms. And so Mr. Lincoln understands that. He understands that when the democratic yearnings in Europe that have bubbled up have been basically dashed in 1848. The United States is the only really democratic project going in the world. And if people are able to undo an election by force of arms, then government of, by, and for the people is a snare and delusion. It's a sham. So he has to resist this because he understands that America is the last best hope of earth, American democracy. And today he's right, because look at the world. But if we are going to be the last best hope of earth, we have to get rid of this thing called slavery. It just can't, it's a deep stain and moral compromise. And that's what he decides. He, in the end, is waiting for, frankly, a sign from God. And Antietam he interprets as a sign that ultimately, because he wants to do God's will, and he doesn't live in an age of overt miracles anymore. And it's a deep sort of problem for people in that era. How do they discern what's right when God doesn't speak miraculously in Old Testament ways, New Testament ways? So he interprets Antietam as a sign that America must end slavery forever, and the Emancipation puts America on an unalterable course. And that's 150 years ago today. And then 75 years ago this week, Franklin Roosevelt gives a very famous speech on Constitution Day, talking about how the Constitution, this is September 1937, for those of you who are counting, the 150th anniversary of the Constitution, the 75th anniversary of Antietam. And President Roosevelt gives a speech in which he talks about how the Constitution is a layman's document. It's not a lawyer's document. It's for ordinary people. Okay, so, and the New Deal is going to give us a very different basic social contract than we had before, in which some of the hard edges of unfettered capitalism are softened by the existence of a social safety net, social security system, for example, that will later ripen into a great society, Lyndon Johnson vision, Lyndon Johnson revered FDR, of Medicare. It's going to give you Obamacare, the same sort of vision. This is a vision that's contested right now, increasingly by a Republican Party that really sounds pre-FDR in some of what it's actually putting forth. So I do want you to at least remember why these things happened, and the changes that were introduced 225 years ago. Democracy in the world on a continental scale, unparalleled. 150 years ago, an end to slavery which will eventually be universal, immediate, uncompensated, stunning in this sort of shift of, it's practically socialistic. This change, this redistribution of property rights from slave masters to slaves. And then 75 years ago, challenging of plutocratic power and economic inequality, and an attempt to basically have a minimum safety net, at least, to soften some of the edges of unfettered capitalism, and to basically affirm a different vision of the proper role of the federal government in people's lives. Okay, so that's the past. Now we have some context. Now here's what I'd like you to do. I'd like you to try to, because if you're serious about constitutionalism, you not only have to think 225 years into the past, and 150 years, and 75 years, and take seriously all that. The reason that a constitution is written down is so that we remember and never forget why we did certain things. And that's what anniversaries are about. They're about recollecting, remembering. So now that we've remembered why we did these things and what we did and how big they were. And 1937 doesn't leave a textual imprint. The founding gives us the text of the Constitution. Emancipation Proclamation is very soon going to lead to the 13th, 14th, and 15th Amendments in the text, ending slavery, promising equal citizenship, promising blacks equal voting rights. 1937 doesn't leave a textual mark. It actually, though, is an embodiment of earlier amendments that have changed the system. A 16th Amendment is a progressive, that is a redistributive income tax. So soak the rich income taxes. That's what it's supposed to be. It's actually, the 1908 Democratic Party platform is word for word the Buffett rule, that basically, certain people should pay, that wealth should bear its fair share of the national burdens. 16th Amendment, 17th Amendment, these are the beginning of the 20th century, even before 1937, the New Deal is going to say senators are directly elected, so they don't have to be picked by state legislatures, so they're going to be more free to pursue national projects, because they don't have to just keep getting reelected by state governments who might be parochial. The 19th Amendment, doubling of the franchise, women get the vote. See, that's very different. 16 plus 17 plus 19 equals the New Deal. It equals Franklin and Eleanor. It equals the Great Society and Obamacare. It equals Michelle and Barack and Michelle, Bill and Hillary. We call that the gender gap today. Women basically tend to vote more for New Deal-ish like approaches to certain things. So 16 plus 17 plus 19, that's actually in the text of the Constitution. And in this election, Barack Obama is probably not going to win the male vote. And he's probably going to win re-election. And it's because of the female vote. It's because of the 19th Amendment, okay? So that's the past. Now, if we can take seriously the past and these constitutional texts that memorialize these things, the original document, the 13th, 14th, and 15th Amendments, the 16th, 17th, and 19th Amendments, and so on. Now I have to turn the telescope around and we have to think forward into the future, 75 years, 150 years, 225 years. Because the Constitution is this intergenerational compact. We have obligations to our posterity. And so the question is, if the founders gave us a better system than they inherited, and if Lincoln and his generation gave us a much better Constitution than Lincoln inherited from his fathers, and if the same was true, the early 20th century progresses, what will be our legacy to our posterity? So this is the last chapter of my new book, which I haven't plugged for in the last 3 minutes, but I'm doing so now. The book is called America's Unwritten Constitution. And an unwritten constitution could mean many different things, and I talked about I gave you an overview of the book the last time I was lucky enough to be here. The last chapter, which I'm going to now spend the rest of my time talking about, is America's unfinished Constitution. There are different elements of an unwritten Constitution. One of them, for example, is how the Constitution actually came into existence. It's not written down in the text, but it actually came about through free speech, I just told you. That's part of the Constitution, even before the First Amendment came along, even though it wasn't written down before the First Amendment. Well, another part of an unwritten Constitution is the Constitution still to be written. The unfinished Constitution, the amendments that lie in the future that this generation or the next or the one after that might plausibly add to the thing. And how might we even begin to think about that? Well, I offer in this last chapter sort of three big ideas, I hope, maybe 3.5, about how to think about the Constitution still to be written. So, so here's one idea. States are going to provide the laboratories of experimentation, American states, for what belongs in the federal Constitution. There are a lot of democracies around the world. Trudy talked a little bit about some of the regimes around the world. And they do things rather differently, and it might be actually sensible for them to do things rather differently, but we're probably not going to just borrow their models unless states begin to emulate them first. There is an American way of doing democracy and constitutionalism that's quite distinctive. And I want you to see the pattern. And I'm not claiming that you can't have an amendment that states haven't done first. I'm saying you won't. It's just as a practical matter, though it's unwritten, the federal Constitution will follow state templates. Here's the basic system of America's 51 constitutions, because there is a distinct American way of doing things. Written constitutions. You see, Britain doesn't have a written constitution. Adopted by some special measure of popular sovereignty, some special measure of popular involvement, initiative, referendum, or I told you about how the Constitution was ratified 200 years ago. 3 separate and distinct branches of government. A bicameral legislature, except in Nebraska. Single-member districts, typically for both state legislators and Congress. 2 political parties, only 2. We see there are lots of places around the world that they have way more than 2 political parties, okay? A president, an executive who's elected independently of the legislature for a fixed term. The legislators also have fixed terms. These things aren't true in parliamentary systems. The legislature picks the prime minister, and the term isn't fixed. You can have snap elections, and the prime minister in these regimes doesn't have a veto. But all our governors look like mini presidents. They're elected independently of the legislature for a fixed, typically 4-year term in, I think, 46 or 48 of the states. They have a veto pen. There's some little variations. There's not always 2/3 override. It's, we have a separate Bill of Rights and judicial review of legislative action, state and federal, for conformance with the state Bill of Rights and the federal Bill of Rights. We have a jury system. A lot of countries don't. See, there's a very distinctive, a lot of things in the federal Bill of Rights are in state bills of rights and vice versa. There is an American model of constitutionalism. And so one claim, it's a political science claim. It's not a claim that you can't go off the reservation and put something in the federal Constitution that states haven't road tested. It's that you won't, because these other things will look too weird and foreign. Proportional representation, parliamentary systems, multi-party governments and systems, and so forth. So if we ever get those things, it'll be because a state or a series of states first does them and they succeed. States are the basic testing ground for, and that's been true for 200 years. 225 years. The U.S. Constitution on issue after issue followed the best state constitutional practice. So how to launch the Constitution, most of them had written constitutions. How to launch it, Massachusetts and New Hampshire had actually put their constitutions to a popular vote of sorts. So the federal framers said, we're going to follow that. All the states except Pennsylvania have bicameral legislatures. States have 3 branches of government, pretty much. We'll do the same. States are already using judicial review for compliance of state statutes with state constitutions. We're going to do the same thing. States have juries. We're going to have juries, and so on. So the federal constitution is basically, Pennsylvania, since I'm here, has a census, so we're going to do this, and reapportionment, so we're going to do the same thing. Pennsylvania has no property qualifications for its lawmakers, so we're going to do the same thing, no property qualifications for our lawmakers. Pennsylvania pays its lawmakers so that less wealthy people can afford to serve. We're going to do the same thing. Massachusetts has a strong governorship, and so we're going to model the presidency to some extent off of that. So 225 years ago, states were the templates. The amendments, states are the templates. States have bills of rights, so the Anti-Federalist says, where's the federal counterpart? States, some of them got rid of slavery. Pennsylvania, for example, gets rid of slavery before the Civil War, and so the federal, ultimately the federal government will model it. So states, some of them are giving blacks equal citizenship and equal voting rights. The federal government, the federal constitution follows suit. Some states give women's suffrage first. By 1890 or so, we have Colorado and Wyoming first, and Colorado and Idaho and Utah all having women's suffrage, and that provides then, and then more states jump on the bandwagon in the early 20th century, and then eventually a tipping point is reached, and the federal constitution follows suit. On issue after issue, already our Constitution has followed the state laboratory model, and so that's one political science prediction. Second, ours is a partisan, actually a bipartisan Constitution. Our 2 parties, although they're not prominent on the surface of the written text, are actually part of how we govern ourselves in America. Ours is a functionally 2-party system, and the 2 parties stabilize the system in all sorts of ways, and the 2-party system is built into the very architecture of the Congress with an aisle between the 2 parties, with all sorts of rules about how many seats each party, as a party, is entitled to on each committee for staff, and what the budgets are for staffers of each party. Our modern administrative state, I mentioned Franklin Roosevelt, and all the administrative agencies, many of them by law have to be divided between the 2 parties. Parties are really built into the structure in a whole bunch of ways. What that means as a practical matter is that in the future, any conceivable amendment is going to have to basically have bipartisan support. Both Democrats and Republicans are going to have to be on board, because you can't get 2/3 of the House, 2/3 of the Senate, and 3/4 of the states with just one party. Now, there have been moments in the past where you've been able to do that. So ours today is a bipartisan Constitution. In Abe Lincoln's day, and I'm wearing my Abe Lincoln tie, by the way, just in case you missed it. His was a very partisan world in which the most conservative Republican was still pretty much to the left, so to speak, of the most liberal Democrat. Just as our world is one in which in Congress the most conservative the most conservative Democrat is to the left of the most liberal Republican. So the 14th Amendment was a strict party line vote, just like Obamacare. Absolutely party line vote. Every single Democrat votes against the 14th Amendment. Every single Republican except one votes for it. The one, by the way, was Joe Lieberman. No, just but in those days, the Democrats, in effect, were hugely underrepresented. They were the party of secession and slavery, and the South actually wasn't going to be let back in, which is a Democratic stronghold, until it agreed to certain basic ground rules. So the 14th Amendment is a partisan project. So is the 15th Amendment. As a practical matter, so is the 13th. There's an election. And a presidential election, and the Republican platform is we're going to get rid of slavery, and the Democratic platform is let's just not mess with the Constitution. And Lincoln wins, and when he wins, a few Democrats in the lame duck period join and vote for the 13th Amendment because they think the people have spoken. But before then, the Democrats basically are opposed to an Emancipation Amendment. The 13th Amendment ends slavery. It constitutionalizes and expands the Emancipation Proclamation. So in the past, the 13th, 14th, and 15th Amendments were kind of partisan measures, but I don't really see one party in our lifetime having that kind of overwhelming hegemony. In our lifetime, epic things that are, as a practical matter, constitutional, although they're statutory, the Voting Rights Act of 1965, the Civil Rights Act of 64, the Open Housing Act of 68, they were passed in bipartisan ways, as a higher proportion of Republicans voting for these great civil rights measures as Lyndon Johnson's Democrats, about 75% on both parties. So your amendments are going to have to get the support of both parties. States are going to provide the template. Third, I think they're actually the amendments that fit of the future have to fit a certain trajectory in order to be really deeply constitutional. Here's an amazing thing. All of our amendments, except Prohibition, which failed, expanded liberty and equality, and none of them contracted liberty and equality. This argues against amendments to prohibit flag burning or something like that, to constrict for the first time the freedom of speech, or to outlaw gay marriage. I'm not saying gay marriage is constitutionalized. I'm just saying an amendment to outlaw gay marriage is very much against the grain of this trajectory of history, whereas amendments to sort of widen the scope of inclusion, to be more equal, more free, sort of fit that trajectory. Okay. Just a couple of specifics, and then let's actually have, let's get a lot of, I want to engage you all in a conversation. So what amendments specifically might be imaginable? Also, what sorts of things could you do without a constitutional amendment? Sometimes you can do workarounds that don't require two-thirds, two-thirds, three-quarters. And what might history tell us about that? Okay, so I told you that all 50 states look remarkably like the federal Constitution and different than the Israeli Constitution and the British Constitution and the French Constitution and the Indian Constitution. There's an American way of doing things. But within that similarity, states do things a little differently than the Fed sometimes, and those are plausible models for reform. Let's take the obvious one. Governors look a lot like presidents, right? 4-year terms, veto pens, pardon pens, sort of independently elected, their own electoral base. They don't get elected by the legislature. They have their own constitutional sort of running mates, sidekicks, lieutenant governors, vice presidents. But how do we pick them? Do we have an electoral college in Pennsylvania to pick the governor of Pennsylvania? No, we do not. One person, one vote. And we count the votes, and whoever wins, wins. And if it's close, we recount carefully. That's how we do it in Pennsylvania. And that's how we do it in California, and in Texas, and in New York, and every big state in America, and every middle-sized state in America, and every small state in America. Now, I've just told you, I told you, that's just not what we do, but kind of, I told you also why we do it. Because of this idea of one person, one vote. It's a very powerful normative idea today, not so much at the founding. They had slavery, wasn't sure how you count slaves, and so it was more complicated then. Now, I've told you enough. Just those little facts. We pick governors just through direct popular election within each state, not with an electoral college, and the idea is every voter counts equally. I've told you a lot now about why direct election for the presidency looks very plausible to many, many Americans, because there's an American model, and governors are mini presidents, and we don't pick governors through electoral colleges, and 80% of the arguments that you've heard for the electoral college, actually, I've just explained, are BS. And they're baloney, because if they really were true, then the states are stupid. They're picking their governors the wrong way. So when they say, oh, well, it prevents regional candidates or something, well, that's true within Pennsylvania. And we pick, oh, it's needed to stabilize a two-party system. No, it's not. You have two parties in Pennsylvania, and it's one person, one vote. And just 80% of the arguments you hear about the electoral college make no sense when you say, well, if that's true, why do states pick their governors this way? So that's a plausible Let's take another one. Let's take the question of whether someone who comes to the United States at a young age and becomes a naturalized American, takes a test, signs up to be an American, makes a conscious choice, should ever be eligible to the presidency. Well, they are eligible to be governors, and even governors of great states. Arnold Schwarzenegger, Jennifer Granholm, and if they're good enough to be governors, why not presidents? And by the way, I told you something else when I just told you Schwarzenegger and Granholm. I gave you a Democrat, Granholm, and a Republican, Schwarzenegger. So I already began to explain why it might one day be in the interest of both parties to do this, because both parties might sort of benefit from it very concretely. They have someone that might be eligible, very attractive candidate. And one day, even the Republican Party will realize that it actually can't write off, the 47. I mean the 47%, the immigrant. I'm just getting confused. They write off so many people. And I'm actually rich enough to be a Democrat. So if they're writing off these 47% of the dependent people, and you add just a few of us rich Democrats, I don't get it. But I digress. Orrin Hatch, great conservative Republican senator, introduced a constitutional amendment in 2004 allowing naturalized citizens after a suitable time in America to be eligible for the presidency. Actually testified in favor of that. Now I haven't heard very much from him about that recently, just because the Republican Party has lurched very far to the right on immigration and a whole bunch of other stuff. But if they lose this time around, if they lose even in the Senate, it's even possible that they could lose the House of Representatives. At a certain point, they're going to need to actually rethink their formula for success. See, because there basically aren't enough going forward into the future, enough grumpy, old, angry, white, native-born men to actually keep winning election after election into the future. So they're going to actually have to retool their formula for success. The demographics are just different today and going forward, and they will eventually find it in their interest to do symbolic and other stuff to reach out and to show that they actually are a party that's open to new Americans and immigrants. And so it's not implausible to imagine that that's a constitutional amendment that you could have happen. Some things won't require, as a practical matter, a constitution. I gave you just a couple of examples, and this fits the trajectory of increasing inclusion. The 14th Amendment makes me a citizen the day I'm born in Ann Arbor, Michigan, even though my parents aren't citizens. They weren't here illegally, but they were students. And the government didn't ask me who my parents were and whether they were citizens the day I was born. They just said, you're equal to everyone else born in this hospital this day. Except the one, but what isn't true yet is that Jennifer Granholm isn't fully equal because she came at the age of 2 from Canada. So she doesn't get to be president, and I do. But an amendment that makes her eligible, that makes Arnold Schwarzenegger eligible, or the people who look, who would like them in the future, that fits the whole flow of the Constitution itself. The Constitution made eligible all sorts of folks who weren't eligible before. 7 of the 39 men who signed their names to the Constitution are foreign-born on September 17th, 1787. And 3 of the first 10 Supreme Court justices foreign-born. 4 of the first 6 secretaries of the Treasury, including Alexander Hamilton and Albert Gallatin, are foreign-born. About 9 of the first members of the first Congress are foreign-born. So ours was a system from the beginning. James Wilson from Pennsylvania, who writes the words "We the People," is an immigrant. And he actually wants the Constitution to sort of be opened. So the Constitution was way more open to immigration than the Brits. In Britain, if you're not born a subject of the crown, you can never be in the House of Commons or House of Lords or Privy Council or hold the high military, any position of honor, trust, or profit. And America makes it much more wide open. And Trudy didn't talk as much about immigration, but I think actually when she mentioned that the future president of China is someone who actually studied here, this is part of our great strength and soft power, that we, not only is the world more American, America is more global than ever before, especially after 1965 when our immigration laws were reformed. My parents come here, our great universities can be magnets. It's, my parents met in Ann Arbor, Michigan. Okay, these two people born in undivided India meet in Ann Arbor, Michigan, and I'm happy that they did. So that's part of our soft power, that we bring people here, so this fits the American trajectory, that kind of amendment I'm suggesting, and it might be in the interest of both parties to do it. So it fits the trajectory, it might be in the interest of both parties to do it, and states have done things like this. You have governors who look like presidents who are foreign-born. So those are plausible amendments. Let me just conclude with two other additional thoughts. One, a lot of reform is possible, because two-thirds, three-quarters is hard. To get two-thirds of the House, two-thirds of the Senate, three-quarters of the states. So a bunch of things you can have happen without formal constitutional amendments. In this last chapter, I give you two different ways you could have direct election of the presidency without a constitutional amendment. One of them is actually now kind of afoot. It's called the National Popular Vote Initiative. States can choose to give their electoral votes one by one to the person who wins the national popular vote rather than the vote within that state. It's up to the state to decide. And a bunch of states have said, we'll give already. A bunch of states have said, we'll give California is one of them, we'll give our electoral votes, all of them, to the person not who wins California, but who wins the national popular vote, if enough other states make the same promise. And if enough states make that promise, actually, it becomes self-fulfilling. If states that add up to 270 electoral votes all make that promise, then the game becomes winning the national popular vote, because if you do, you automatically get all of those. And this was an idea that I floated on the web. Just posted something on the internet in December of 2001 as a thought experiment, and actually a version of it is now afoot in the States. I also suggested a different way of getting to the same result, that if 4 people, if they're the right 4 people, believe in direct national election of the presidency, they could achieve it, believe it or not. If you have a question about that, maybe I'll give you a little hint. In my hypothetical, when I'm imagining this, I also talk about how one person who might be witness to these 4 people making a certain agreement might be Jim Lehrer. But it could be Candy Crowley or Bob Schieffer. That may give you a hint about who the 4 people need to be and how actually this could happen. It's basically, not to be too coy, the 2 presidential candidates and the 2 vice presidential candidates, if they made agreement among themselves, could actually give you direct election. In the same way that that Elizabeth Warren and Scott Brown can agree on certain rules about how they will actually spend money or not spend money between themselves, or they're going to meet for a whole bunch of presidential or senatorial debates or something like that. Elections are decided in America not just by counting and recounting votes, but basically by concession speeches, by the candidates themselves. And so now where am I getting this idea that you could move to direct election of the presidency as a practical matter without a constitutional amendment? Because we had a 2-term tradition in America, way before a 2-term amendment by practice, tradition. Washington steps down, and then after him, Jefferson and Madison and Monroe, and it's not strict. FDR is able to transcend it, but it was pretty powerful still. Before direct election of the senators and a constitutional amendment, the 17th Amendment, we had something very closely approximating it, beginning as early as the Lincoln-Douglas debates, as in Mr. Lincoln. The parties told Illinois voters in advance whom they were going to nominate for the U.S. Senate. The Republicans said, Abe's our man. The Democrats said, we're going to elect Stephen Douglas to the U.S. Senate. And they told voters that before the election, which turns the election of the state legislature into a de facto referendum of sorts. If you want Lincoln, vote Republican for state legislature. If you like Douglas, vote Democrat. It's not perfect direct election, but it was actually a pretty close approximation. And other states did things that were even more closely like direct election before the text was formally ratified. One final mind-blowing suggestion, and then let's have questions. We could even, here's another way in which states differ from the federal government. No state has a malapportioned upper house, whereas the Senate is malapportioned. California counts for the same as Wyoming in the Senate. And the Constitution says that you can't change the rules of the Senate unless of apportionment. So this looks weird and un-American today in a way that it didn't look weird and un-American in 1963, because in 1963 the Warren Court hadn't required one person, one vote, proportionately representative upper houses. But now the Senate looks kind of un-American because none of the 50 states do that. And we have this deep idea of one person, one vote. It's part of our kind of American ethos. So the Senate looks more odd than it did before, but the Constitution's text seems to say you can't fiddle with the apportionment of the Senate unless every state agrees, and as a practical matter, that's impossible. And I say, well, actually, you need an amendment to do it, but just an ordinary amendment, 2/3, 2/3, 3/4. Why just an ordinary amendment? Because the ordinary amendment doesn't reapportion the Senate. The ordinary amendment creates a new body. Let's call it the Schmenet, and gives all the powers of the Senate to the new body, the Schmenet, except maybe the old Senate reserves the power to try the impeachments of assistant postmasters general or something. But everything else goes to this proportionally represented Schmenet. Now that's still going to require 2/3 of the House, 2/3 of the old Senate, 3/4 of the states, with Wyoming counting equally than California, but it doesn't require state unanimity. Final thought, well, why would Wyoming ever go for that even now? And a bunch of the other small states, why would the senators for Wyoming ever go for that now? So here's the final thought. How could any amendment escape the gravitational pull of an arguably unjust status quo? Why would people who have power now, even if they recognize the power is kind of corruptly apportioned, ever agree to rule changes? The thought is we could have sunrise amendments. You've heard of sunset laws, laws that lapse after a certain time. The Bush tax cuts are due to sunset. A sunrise law is a law that doesn't go into effect until sometime in the future. Now, for ordinary elections, this would be weird. We vote today, but the person takes office 30 years from now. That'd be a little weird, more than a little weird. For ordinary laws, may not make sense. But ladies and gentlemen, I've tried to tell you that the Constitution exists on a longer time scale. We're thinking 225 years ago. We need to project 225 years in the future. We need to think about our distant posterity. And for a constitutional provision, the idea that we're going to carve out some rules, but the rules won't go into effect now, won't go into effect in 5 years, will go into effect 50 years from now. These are what should be just rules for our grandchildren. Fair rules, what Rawls called rules that we're adopting now behind a veil of ignorance, because we don't know who's going to be benefited or disadvantaged 50 or 100 years from now. We can be founders for the future, for posterity. So here's what I would say to my friends from Wyoming. If you think it really is deeply just and fair that you in Wyoming count for more in the Senate than someone in California, well, then stick with what we've got, because you actually think it's fair. But if deep down you think it's not really quite right, that some Americans count for more than others, but you don't want to change the rules because you benefit from the existing rules, remember this, my friend, my Wyoming friend. We can call him Jefferson Smith if you like, with a tip of the hat to Jimmy Stewart. Your great-grandchildren are not likely to be Wyomingians. They're as likely to be Californians or Coloradans or Pennsylvanians. Why should you favor your Wyoming posterity at the expense of your California posterity? Why, shouldn't you hold them all equal in your moral imagination? And so, if we're willing to think back, it's one problem with democracy. It's very hard for democracy to bootstrap itself off the ground, come up with fair rules for how it should govern itself. Who decides? Who decides? Who decides? Just what are the fair rules for generation one? That's very difficult to do. But we can come up with fair rules. That's what constitutions do for how power should be allocated 50 years from now in America, 100 years from now in America. And we might be wrong about, but at least we'll be asking a question of justice, of fairness, rather than what's in our interest today. Let me actually close with a quotation from 225 years ago. So hang on. So where did the founders go most wrong? What was the issue that they screwed up? Slavery. And that's because they were dependent on, their interest dependent. They knew it was wrong, but they knew it was wrong, but it was in their interest. What should they have done? They already did a little bit. They said, we're going to allow slaves to be imported from Africa, even though these are people born free and they're being killed and clubbed and captured into slavery in bloody wars in Africa, and even though they're then being shipped in a middle passage, a hellish middle passage, in which a bunch of them die, Amistad, we're going to allow that for 20 years because our interests demand it. But after 1808, Congress can prohibit the international slave trade. If they had been more farsighted, they would say, and after 1808, we're going to prohibit slavery in the West. And after 1808, no more bonus, the 3/5 for extra, no more extra seats for extra slaves. The way you're going to solve the Palestinian problem is going to be, you're going to have to use time. You're going to have to come up with long. Great. Can you hear me now? Okay. So they could have used more creatively the sunrise idea. Slavery now, but not slavery forever. We're addicted to tobacco or to foreign oil, but we don't want our grandchildren to share our addiction. So let me just close by reading you language of the richest guy at Philadelphia. His name was Mitt Romney. No, his name is George Mason. And he sounds a little different than Mitt Romney. We ought to attend to the rights of citizens of every class of the people. I've often wondered at the indifference of the superior classes of society to this dictate of humanity and policy, considering that however affluent their circumstances or elevated their situations might be, the course of a few years not only might, but certainly would, distribute their posterity through the lowest classes of society. Every selfish motive, therefore, every family attachment ought to recommend such a system of policy as would provide no less carefully for the rights and happiness of the lowest than of the highest order of citizens. Because 100 years from now, they'll all be my posterity, our posterity. So that's this really radical idea. If you're willing to think 225 years in the past, try to project forward in the future, and try to think of what would be fair rules, deeply just rules for our posterity. So thanks very much, and I look forward to hearing your questions.
You need to use a microphone because you're being recorded, so if you don't use it, then your voice isn't. Speak closer.
Thank you. You've raised a number of issues that, in my mind, move in a direction, but I didn't hear you use the phrase. You raised one person, one vote. You raised the issue of wealth making a difference. So my question is the Court decision, Citizens United, on your radar, either as something that can be handled, assuming that you might have disagreed with it, could it be handled by another Supreme Court decision reversing the first precedent, or would it have to be handled by an amendment?
The case of Citizens United could be reversed by an amendment. I don't demonize the case as much as some people do. I believe very much in campaign finance reform, but I think McCain-Feingold was actually not the best way to do it. Since I've been poking fun at Mitt Romney, he's got half a point when he says corporations are people in the following sense. They're not people when it comes to one person, one vote. But I'm deeply grateful to a corporation, Basic Books, for publishing this book, or the last book, Random House. And I wouldn't want government to be able to shut down the Random House or Basic Books or the New York Times, which last time I checked was a corporation. Yale University is a corporation. And even if I could shut down all the corporations, there are wealthy individuals. Mitt Romney is one of them. I actually know a couple of billionaires, and they spend their money, and they're not corporations. So I don't think the problem is corporations as such. I think it's that we have to preserve the idea of one person, one vote, and we need serious campaign finance reform. And I can give you serious campaign finance reform that doesn't violate the Citizens United principles. I can give you a regime. Here's one that basically the biggest problem with advertising is effective because people don't know the truth, because they don't pay any attention. The written Constitution says you have a right to vote. The unwritten Constitution says you have a duty to vote. Responsibility. And the unwritten Constitution also says you have a responsibility to know stuff before you vote, but we're not making it easy for you to do that because you've got a life, and you punch a clock, and you've got other things to do, and you've got kids to raise and bills to pay. So we should actually, and you're more vulnerable to these silly ads that are false because you don't know anything, because you pay a lot more attention to, stuff that matters in your daily life, how your kid is doing, what your church is up to, whether you're going to be able to pay your bills or not. You invest a lot of attention in those things because they matter to you. You feel the effects. If you don't pay attention to the common good, it doesn't affect you that much because your vote doesn't really usually impact the election. So, what should we do? We should the government pay you to take a day off and bone up on the issues the way we pay you for jury service. And then you're going to be much less vulnerable to these soft ads. Could we do other things? Yes, we could do a whole bunch of other things that would be serious campaign finance reform. The government could give every American a $20 voucher that you can't use to buy tennis shoes or hamburger at the grocery store, but that you can give to the candidate of your choice. And now the game becomes not raising $20,000 from one person, but raising $20 from 1,000 people in this very different sort of campaign financing way. We could have publicly funded campaigns. We could have free access to the airwaves. We could create a culture in which people who don't participate in the debates are basically seen as not credible. We could do a lot of things that I think don't run afoul of the idea that even corporations are important, expressive entities in our system. Because I wouldn't want the government to be able to shut down the New York Times.
Is it possible there can be a replay of Gore versus Bush?
Yes.
And also, how would it be handled in the state of Pennsylvania with voter identification needs?
It's a huge problem in several key states. The words right to vote didn't appear in the original Constitution because of slavery and property qualifications, but those words now are in 5 different amendments. The 14th Amendment, Section 2, the 15th Amendment, the 19th Amendment, the 24th Amendment, the 26th Amendment, and the Supreme Court during the Warren Court era, and I have a chapter on the Warren Court, affirmed a basic free-floating right to vote in general. And there's a specific right to vote free from poll tax disfranchisement, and that happened in our lifetime, and people bled for that. John Lewis bled for that in my lifetime and lifetime of most of you all. And that is at risk, right? Right now, in a bunch of states, there have been laws passed for partisan purpose that go way beyond any legitimate interest in suppressing voter fraud, and I don't believe in voter fraud. I'm not for it. I'm against it, for the record. But in-person voter fraud through voter ID fraud is very implausible because you'd have to truck busloads of people in, and when you do that, actually you leave a trail and you get caught. So there's all sorts of voter fraud that might happen, but not this. It's not about people impersonating others on election day. There's absentee ballot fraud. There's fraud when people actually run the voting machines, spin the dials in the back. There's all sorts of stuff, but generally not in-person voter fraud by individuals. It tends to be by the officials themselves who say all sorts of people who are dead have voted and a bunch of stuff. So in our lifetime, we adopted an amendment, Republicans as well as Democrats, the anti-poll tax amendment, and this is under assault in a whole bunch of states: Ohio, Wisconsin, Pennsylvania, Florida, and in case you missed it, those are some key swing states. So yes, the Electoral College could turn on all this. I told you how far ahead of the world we were 225 years ago. We give the world democracy. It is an embarrassment. Our electoral administration today is no longer the envy of the world. And since Trudy talked about how our economy has been a little embarrassing, our economic performance, and this weakens our soft power around the world, we have to do democracy right, not just for ourselves, but for the rest of the world. And we're not, and it shouldn't be this partisan thing. So shame on those folks who actually didn't remember 225 years ago and 150 years ago, and their own lifetimes, and what their own great Republican Party, the party of Lincoln, did in my lifetime to protect voting rights. The worst people on voting rights in my lifetime at the beginning were the Democrats, Southern Democrats, okay? So I'm trying not to be partisan. I'm trying to say the Republican Party should remember actually its truly great contributions, which include Lincoln and include an anti-poll tax amendment. And what is happening in Ohio and other states is absolutely shameful. Absolutely shameful. And where is Mitt Romney on this? Paul Ryan, where are you?
There are two areas. One, you did not address one of the notable failures in amending the Constitution that has been taken care of by many of the states, but that's the Equal Rights Amendment.
Yes.
And secondly, you've gotten into the right to vote, which you noted is not in the Constitution. We recently in Pennsylvania had a Supreme Court argument over the voter ID that had to be focused on our state Constitution.
Yes.
So that wouldn't, in fact, it be better to be able to address that on a federal level as well as that, and how would you propose it? And if corporations are people, what does that do to their right to vote in terms of elections?
So an entity can be a part of the people and not part of the people. Corporations right now under existing doctrine are protected for certain purposes under the Equal Protection Clause. They, for example, you can't discriminate against the New York Times just because you don't like the New York Times, but they're not people for the one person, one vote idea. So only lawyers understand this, but it is, whenever you ask a lawyer, a question, a lawyer will often ask, why do you ask me that? Because depending on why you're asking, I might give a different answer. So if you're asking me about voting rights, they're not people, they're not persons, but do they have property rights? Yes, no person shall be deprived of property without due process. You can't take away a corporation's sort of property just by saying, well, it's not a person. You can force a corporation to testify against itself. They don't have Fifth Amendment protection against self-incrimination, because for that purpose, they're not a person. And you know why? It's actually very interesting. It's because the self-incrimination clause, and this is true, I'm not making this up, is designed to protect people's souls from temptation and moral torture. And again, I'm not trying to be glib, but corporations have no souls. And that's why they're not protected for the self-incrimination, which is in the Fifth Amendment, as in I take the Fifth, but they are protected for just compensation, which is in the very same Fifth Amendment. You can't take away a person's property without just compensation. So they can be persons and not persons for similar purposes. I have a whole chapter on the Warren Court which is part of our unwritten Constitution, and it did say there's a kind of free-floating right to vote above and beyond the specific amendments that say no violations of right to vote on grounds of sex or race or failure to pay a poll tax or age if you're over 18. So the court today has taken those little textual dots and in fact drawn a line between them, read between the lines, interpolated between them, and says there's actually a more free-floating right to vote in general. And it absolutely can't be denied for these 4 reasons, but even elsewhere, it's a presumptive right, and I actually agree with that, and I defend it. There's a free-floating right to vote of sorts, not in the Founders' Constitution, but in ours. And since I'm mentioning case law, there's another chapter on case law, and since you mentioned the ERA, yes, we don't have a formal ERA, but the 14th Amendment says we're all equal, and it doesn't use the word race, so that is an ERA of sorts. And the Supreme Court reads the 14th Amendment as if it were an ERA in a whole bunch of cases, saying you can't have sex discrimination without a very, very strong, compelling, almost, government purpose. So a lot of and the 9th Amendment says there are unenumerated rights. So not all the rights that we have as Americans are textually specified. There are unwritten rights. The text doesn't say you have a right to play the fiddle or to have a pet dog or to wear a hat or to raise your kids. It doesn't say in so many words you have a right of privacy. It doesn't say in so many words you have a right to take the stand in your own defense in a criminal case. But these rights and many, many others have been recognized in actual American practice on the ground. So, and by courts, and I talk in actually several chapters about the significance of unenumerated rights. And the right to vote free from all sorts of discriminations that aren't explicitly mentioned in the right to vote provisions is indeed such an unenumerated right as well. Since you mentioned equal rights for women, I've been remiss. There is a chapter all about women's rights and the feminist revolution and how different our Constitution is from the founding, even though it's not all specified. The text of the 19th Amendment says you have a right to vote if you're a woman, but it doesn't say you have a right to run for president. And the Constitution says he, him, his, but it's obviously unconstitutional for some state to say Sarah Palin can't run for president and be on the ballot, or Michelle Bachmann. See, I'm trying not to be partisan here. This is, you have an obvious right to vote. Because the text says so? Explicitly, no, but because that's part of our unwritten constitutional tradition. Woman suffrage has dramatically changed our Constitution in practice. It's, as I said, given you Franklin and Eleanor, Bill and Hillary, Barack and Michelle. It's changed even how we think about politics and running mates. And I'm fully aware that I'm in the home, the birthplace of Joe Biden, but Barack Obama has 2 running mates, not 1. And the other is named Michelle Obama, and she could actually succeed him. She's a Harvard Law grad too, pretty impressive. And so could Hillary Clinton, for that matter. And that wasn't true in the founders' world. Martha was never going to succeed George. Dolly Madison was never going to, succeed James Madison. Abigail Adams is very similar in persona. She's a brilliant politico. She's a political junkie. Very similar to Eleanor Roosevelt. Very similar to Hillary Clinton. Very similar to Michelle Obama. But she has to play it differently, play the role of being a woman differently, because she can't run in her own right in a way that these others can. So the 19th Amendment is huge and epic. So yes, we don't have a formal ERA, but we have something every bit as big and audacious and effective, actually. And it comes partly from women voting, and so did I mention that let's take Obamacare. The men on the court voted against it 4-2, but it was the 3 women on the court, who sustained Obamacare. They were decisive for Obamacare. You could call it Pelosi care, if you wanted, in honor of the first female Speaker of the House. That's a 19th Amendment phenomena. So we really do have a huge ERA, huger than you ever sort of would notice if you just looked at the written Constitution.
Yeah, do you think, talking about the Obamacare...
Okay. Last question, I'm told.
Okay.
But I'm happy to, mix it up and talk with you all, afterwards. I came here to meet and talk to you all.
Talking about the Obamacare decision, do you think that's going to have a big impact on how the Commerce Clause is applied in the future? How the Senate, any rules that Senate makes, or is going to be interpreted in the future?
I think a lot depends on who wins this presidential election. Since Trudy mentioned China, and she mentioned national security advisors who have sometimes been as important as, maybe more important than secretaries of state, I can't resist telling you, I don't know if it's true, but it's a very widely circulated story that Henry Kissinger, when he was meeting Zhou Enlai, before in a secret mission to China, asked Zhou Enlai what he thought of the French Revolution. And Zhou Enlai said, "Too soon to tell." And that tells you a lot about China and their deep sense of history and sort of wisdom. So it is a little soon to, and here's why it is. Because if Barack Obama wins re-election, that's a very different Supreme Court probably going forward. Maybe not a balance shifting. Different people resign. See, there may not be a balance shifting thing. If Obama wins, then Ruth Bader Ginsburg maybe resigns in his third year in the second term, and she clones herself. Maybe Steve Breyer does that. He, in effect, clones himself. Their first choice is to live forever, but since that's not given to them, their second choice is to clone themselves by timing their resignations. Alternatively, if Mitt Romney wins, then Antonin Scalia may be in the third year of Romney's first term, sort of steps down and tries to clone himself. So, and depending on that, then the Supreme Court's ruling restricting federal power under the Commerce Clause becomes maybe, not very important in one alternative universe and hugely important, sort of the transition to a different regime, trying to push back on the New Deal pretty considerably in the other alternative universe. So many reasons why you must vote and must apprise yourself on the issues. Most importantly, not because it's going to make a difference. It will not. If anyone tells you that, they're just lying to you. If it's close, actually your vote won't count, and if it's really close, someone else will cheat. That's not why, see Bush versus Gore, that's not why you vote. That's like saying, well, don't commit murder because you might get caught. They do not teach that here at the University of Scranton. They teach, do not commit murder because it is wrong. And do not abstain from voting because that's wrong. People died for this, okay? And some folks around the world don't take it for granted, actually, even if some of you all do. So you must vote. You have a duty. It's unwritten, but a duty to vote and a duty to inform yourselves of the issues. And you're absolutely right. One of the issues, you haven't heard very much about it, but one of the issues is the future of the judiciary. Many reasons for you to take this seriously. So thanks so much for having me again.
The last thing I really want to do is stop this conversation, but it will continue. It will continue during the book signing, which we'll go to now. Those of you who wish to buy a book, it's $30. And Akhil will be glad to sign it, and I'm sure talk to you over lunch or wherever. The conversation goes on, but thank you very much. Fifth floor. Thanks for asking. Fifth floor, 509.
Right out here is the book signing.
The book signing is on this floor at the desk, right outside.